Okay, I wanted to do an interview with somebody about the rules of professional conduct and what they can do about it. So I wanted to use the rules of professional conduct as a questionnaire. Look at it. It says the rules of professional conduct were adopted by the ABA House of Delegates in '83. They serve as a model for ethic rules for most jurisdictions. Okay, so basically, it's every state adopted to it. Okay, so table of contents. Okay, what's going on here? Okay, so everything's just going to be a question. I'm going to start with the preamble and the scope. Okay, every number is a question. A lawyer is a member of the legal profession as a representative of clients and officer of the legal system and a public citizen having special responsibility for the quality of justice. Okay, do you feel that's true, yes or no? As a representative of clients, lawyer performs various functions as an advisor, etc., etc. So everything here is going to be a question. Okay. The lawyer shall be competent, prompt, and diligent. The lawyer should maintain communication with the client concerning the representation. So a lot of that's going to be a yes or no answer. Did that happen with you? A lawyer should keep in confidence information relating to representation of a client, except for as far as disclosure is required or permitted in the rules of professional conduct or other law. Okay, a lawyer should conduct and conform the requirements of law, both in the professional service of clients and the lawyer's business and personal affairs. Okay, so these standards are set forth not just in their professional life, but in their personal life as well. So you're going to want to go through all this as a questionnaire, okay? Scope. So these are a lot of questions you're going to want to ask yourself or ask somebody else. Interview somebody for this, okay? Because I could tell you there's going to be a lot of no's, okay? A lot of no's to that. Now that's just the preamble and the scope. Okay, how about the rules themselves? Terminology, competence. Okay, competence. The lawyer shall provide competent representation to a client. Competent representation requires a legal knowledge, skill, and thoroughness, preparation reasonable necessary for the representation. So you might think they act in a competent manner, but once you get into the rules, you'll find out more. Okay. The lawyer shall abide by a client's decisions concerning objectives and representation as required by Rule 1.4. Shall consult with the client as to the means to which to be pursued. The lawyer may take such action on behalf of the client as completely authorized to carry out representation. The lawyer shall abide by the client's decisions. So these are a lot of questions you're going to have to ask yourself. Diligence. The lawyer shall act with reasonable diligence and promptness in representing a client. And I'm quite sure all of you feel that they haven't done it, especially when, you look up a quick and speedy trial and find out they weren't diligent, they weren't competent, they didn't communicate to you that you had the right to a quick and speedy trial, and the state's attorney exceeded that, so your attorney had the right to have the case dismissed with prejudice. But he didn't, because it doesn't pay. Confidential information, you want to go over that. There's a lot of things you're going to want to ask yourself or other people if you ever needed a lawyer. This is where it's supposed to start. Okay, this is where effective assistance of counsel starts. This is where disclosure starts. Okay, this is the beginning of informed consent. In order to receive that informed consent, or to give that informed consent, you must have reasonable knowledge to make an informed decision to give informed consent. And knowing all this would be that disclosure. I mean, it's necessary to divulge this. declining, terminating, or terminating representation. A lawyer will quit on you in a heartbeat if you even mention the rules of professional conduct. A lawyer shall inquire into the essence of the facts and circumstances of each representation, whether the term may accept or combine. Okay, but you'll find that they don't care about any of this. Advisor, podcasting, meritorious claims and contentions. Okay, lawyers shall not bring or defend proceedings or assert an issue there unless there is a basis in law or fact in doing so that it is not frivolous, which include good faith arguments for an extension. Okay, that doesn't happen. Expediting litigation. Lawyers shall make reasonable efforts to expedite litigation consistent with interests of the clients. And that goes for the opposing party as well. Fairness to the opposing party's counsel. You want to check that out. Impartiality and decorum of the tribunal. You're going to want to... There's trial publicity. Lawyers as witness. Special responsibilities of prosecutor. The prosecutor in a criminal case shall refrain from prosecuting charges the prosecutor knows is not supported by probable cause, but they'll do it anyways, and that usually starts with the public defender telling you, here, sign this and you can go, and then you sign that piece of paper unknowingly and unwittingly, leaving with a felony. And it's the prosecutor's supposed to stop that. That's an ineffective assistance of counsel in its entirety. Okay, and it was the prosecutor's job to stop that. And if you go through this, it'll tell you. And if people were asking me about if they have exculpatory evidence, where can they find a decent civil rights attorney, and yada, yada, yada. Well, it just happens if a conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further investigation, make reasonable efforts to cause an investigator to determine whether the defendant was convicted of an offense the defendant did not commit. When a prosecutor knows of clear and convincing evidence establishing the defendant in the prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor will seek to remedy the conviction. Yeah, and that ain't happening. Okay, so people, there's a lot of stuff, truthful statements to others. I'm going through a wrongful eviction, and the attorney is lying, so this is called, actually disinformation. This falls under the category of a disinformation, which is, there's penalties for disinformation. Communication with person represented by counsel, dealing with unrepresented person. I got arrested. State's attorney came in and tried to offer me a deal, and I asked her, who are you? Are you the public defender? Well, we don't do that here. I said, oh, so you're the state's attorney? And I said, yeah, well, dealing with an unrepresented person, is that even legal? And they took off. Okay, responsibilities, partners, managers, and supervisors. So they're supposed to be making sure every other subordinates do this. Responsibility, subordinate lawyer, they're not doing this. Okay, remember podcasting too. Unauthorized practices of law. So there's going to be a lot of questions you're going to want to ask, okay? Misconduct. I told you, not doing breaking any one of these rules is misconduct. Violate or attempt to violate the rules of professional conduct, not only assist or induce another to do so through the acts of another, is called a conspiracy against rights under the color of law, if they help or induce somebody else to do so. So no matter what court you're in, no matter what you're in court for, there's always a conspiracy against rights under the color of law, which is a violation of federal law. Commit criminal act that reflects adversely to a lawyer's honesty, trustworthiness, and fitness as a lawyer, and in other respects. See, so these are all questions you're going to want to ask when you interview somebody or interview yourself. Okay, remember, reporting misconduct is mandatory. A lawyer who knows another lawyer has committed a violation of the rules of professional conduct raises substantial questions as to the lawyer's honesty, trustworthiness, or fitness as a lawyer, or in other respects shall inform the appropriate professional authorities. Failure to do so is misconduct. And failure to report misconduct creates a conspiracy against rights under the color of law, because that lawyer knows if he reports the other lawyer, then the other lawyer is going to have to report him, and then they're going to have to report the judge, and everybody has to report each other and themselves as well. You can literally cite your attorney for misconduct for failure to report the state's attorneys for misconduct for their failure to report your attorney for multiple counts of misconduct. Disclosure. This rule does not require disclosure of information otherwise protected by Rule 1.6, but disclosure is mandatory. You can look that up. We talked about that, okay? And so none of this has happened, okay? So this is where you want to go, okay? An ineffective assistance of counsel motion, IAC motion, claims the defense attorney performance fell below the reasonable professional standards, violated Sixth Amendment rights under Strickland versus Washington. Such defendants must prove that the attorney was incompetent and a deficiency caused prejudice, meaning that the result would likely have been different. Yeah, if they just did their job, played by the rules, made sure everybody else did, made sure everybody played by the rules and the codes, you wouldn't have suffered deprivation of rights, and you wouldn't have suffered a conspiracy against rights under the color of the law. Imagine if only everybody maintained the oath, lived up to the oath. You know there's penalties for violating the oath, right? Look it up. It's on the net. And they might try to tell you otherwise. This doesn't mean what you think it means. Don't believe your eyes, believe me, which is disinformation. That's violating the letter of the law. The letter of the law strictly requires all of this to be done word for word to the letter. Okay, that's mandatory. There's penalties for violating the letter of the law. There's penalties for disinformation. So remember, disinformation, illegal. Ineffective assistance of counsel, illegal. And it's easy to prove ineffective assistance of counsel with the rules of professional conduct. One cannot willingly and knowingly dismiss the rules of professional conduct because that's violating the oath. That's deprivation of rights. That's depriving you of effective assistance of counsel. Without effective assistance of counsel, you will not get a fair trial, and that clearly shows due process did not exist. Okay, people, I'm just pointing some things out. I like to peruse the internet and talk about what I read. And I read it word for word to the letter. I had some individual questioning me what I meant by what I read, and I only read the law. And he got a little upset because I didn't try to explain these words. I pretty much thought it self-explanatory. But to me, it sounded like a lawyer having me up on the stand and trying to get me to say something other than what I said, and then turn around and tell me, you didn't say that, you said this. Trying to get me to... No, I told him, hold me to the letter of the law. I said what I said. I told him, he wanted to know. I said, I read words to the people. And he said, oh, you sound like one of those sovereign citizens. Whatever. I said, no, I just reading the law off the internet like I'm doing now. And people are listening to these words that I'm reading. I said they had this thing called Kindle where they read stuff to you. So instead of books, I'm reading laws. So they're giving you examples of ineffective assistance of counsel. And I just gave you a whole lot of what they ain't doing to prove ineffective assistance of counsel. It's all here. Okay, it's here. And they're supposed to enforce the Code of Judicial Conduct as well. So remember, it's the legal responsibilities, obligations, contractual obligations, constitutional duties of all lawyers and judges to abide by and enforce the rules of professional conduct and the code of judicial conduct, which are the laws within a court of law. All right, thank you. Good night. May your Creator always be with you and rain many blessings. I wish you a long life and good health. And, if everything goes as I like, who knows, maybe somewhere in the near future, if we can get these public servants to abide by the law, you will have universal health care. At the very least, Medicare for all. I'm old. My time's about up. So it's not about me. It's about you. I want to see you live a life way better than I did. All right? Okay, so remember, here's your ammunition, all the stuff they didn't do. And here's where you go. Okay. So you got, just look. That's all you need to prove that they didn't do any of that, and it's all said and done. It's over.